curious. I'm not pushing back in any way. I wasn't there. What makes you think that Ms. Jones would know why you were giving her daughter some money?
Enjoy the video. Hit the like button.
Let's get on the record in this matter. This is State versus Jones. It's 25 SC 002-906. And I believe we are here to handle this case by way of a negotiated plea. Is that your understanding, Mr. Wooten?
It is, Your Honor.
And Mr. Wooten is here for the state. Mr. Campbell is here for Ms. Jones. Good afternoon, Mr. Campbell.
Good afternoon, Your Honor.
Thank you for navigating World Cup traffic and being here.
Yes, I thank the court for having me and apologize. It's been a lengthy day of being in Fayette and Cobb County today.
Well, now you're in Fulton. We'll see how much more of your day is spent here. But what we're going to do is move forward with Ms. Jones's plea. And Mr. Wooten mentioned before you got here that he thought it was negotiated. He shared with Ms. Nelson, my litigation manager, a set of conditions. And my question was, is this something that you and Mr. Campbell have agreed to, or is that part of what I'll be doing? And it was Mr. Wooten's sense that it was a negotiated plea.
It is a negotiated plea, Your Honor.
Okay. Well, then we'll get started in just a moment, Ms. Jones. Mr. Wooten will put you under oath and then ask you questions about your rights as a criminal defendant, as well as questions about this case. You need to answer his questions truthfully and completely. If you at any point want to confer privately with Mr. Campbell, just let me know. You guys can step back from the podium and discuss what you need to. And if you have any questions for me, let me know so that I can try to address them. Will you do that? Yes. Okay. And make sure you speak up. The court reporter needs to hear you through our AV system. Mr. Wooten, when you're ready.
Thank you, Judge. Ms. Jones, if you could raise your right hand for me, please. Do you solemnly swear or affirm that the testimony that you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth?
Yes.
And could you please state your true and correct legal name?
Tricella Trisha Jones.
And Ms. Jones, are you the same Tricella Jones listed in indictment number 25 SC 002-906?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No.
And is there any medication that you normally take that you have not taken today?
No.
How old are you?
52.
How far have you gone in school?
Master's degree.
And are you able to read, write, and understand the English language?
Yes.
And do you understand that you are charged in the indictment with the following offenses in count 1, violation of the Georgia RICO Act, in counts 2 and 14, theft by taking, and in counts 15 and 27, securities fraud?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty, or if you remain silent, that you would have a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
Yes.
And do you need any additional time to discuss the case with your attorney?
No.
Are you satisfied with his services?
Yes.
And Attorney Campbell, are you satisfied that your client has a full understanding of these proceedings?
I am.
Ms. Jones, have you reviewed the indictment in this case?
Yes.
And counsel, does your client waive formal reading of the indictment?
She does.
Do you also waive any and all defects in the indictment for the purposes of this plea?
We do.
And Ms. Jones, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Is the defense aware of any outstanding warrants?
We aren't.
And Ms. Jones, do you understand that you are entering a guilty plea? And my understanding that it's a guilty plea under Alford versus North Carolina. So an Alford plea to the following offenses, and that these are the minimum and maximum sentences provided by law for those offenses. In count 1, minimum of 5 years up to 20 years. In count 2, theft by taking, minimum of 2 years up to 20 years. In count 14, theft by taking, minimum of 1 year up to 10 years. And counts 15 and 27, both are securities fraud, minimum of 1 year up to 5 years. Do you understand that that's the minimum and maximum you could be sentenced to?
Yes.
And do you also understand that this is a negotiated plea of guilty, which means that the state will make a recommendation, the state and the defense will make a joint recommendation to the court as to your sentence?
Yes.
And Judge, do you want that recommendation now or at the end?
Really whenever you want, but only once. So if you were going to do it now and at the end, don't. You should put it where you think you need it.
I'll go ahead and put it on the record now. So Ms. Jones, I'm going to read through and just let me know if this is your understanding of what the negotiated plea agreement is. But on counts 1, 5 years on probation. On count 2, 5 years on probation concurrent. Count 14, 5 years on probation concurrent. Count 15, 5 years on probation concurrent. And count 27, 5 years on probation concurrent. An effective sentence of 5 years on probation, that you would be sentenced pursuant to the First Offender Act. You would receive a behavioral incentive date, which means early termination if you comply with all the terms of your sentence required by law, and that would be 3 years from today. The special conditions of the plea would include the following: that the $10,000 cash bond that you posted in this case would be surrendered to the registry of the Fulton County Superior Court and would be distributed on a pro rata basis to the victims listed in the indictment. And we will provide a separate order to the court as it relates to those amounts. You will have to complete an anti-theft course within 90 days of today. You shall have no contact with any listed victim in the indictment. You shall refrain from engaging in any conduct that constitutes acting as or holding oneself out as an agent, broker-dealer, institutional investor, insurance company, investment advisor representative, issuer, or any other position or profession associated in any way with the offer, sale, purchase, or any other dealings in securities. You shall refrain from engaging in any conduct that constitutes acting as or holding oneself out as any position or profession associated in any way with the offer, sale, purchase, or any other dealings in insurance. You must not conduct any financial transactions on behalf of any other person. You must not serve as an accountant, bookkeeper, fiduciary, or holder or manager of funds for any other person, organization, business, group, or other entity in any capacity. And within 48 hours after your entry of your guilty plea, well, your offered plea today, you shall provide to the district attorney's office through your lawyer a truthful sworn affidavit stating to the best of your knowledge the current physical location of Kayla Brown. And at any time thereafter that you learn that Kayla Brown's physical location has changed, or if you require additional information concerning her whereabouts, you shall provide a supplemental sworn affidavit through counsel within 48 hours of learning that information, and that condition will terminate once Kayla Brown has been taken into custody. Is that your understanding of what the agreement is?
Yes.
And are you aware that the court does not have to accept that recommendation and that the court could sentence you to the maximum on each charge and could run those sentences consecutively or one after the other?
Yes.
Do you understand that you would have until the end of the term of court to file a motion to withdraw your guilty plea?
That's why I was planning to I'm out something the longer 30 days or by the end of the term of court.
Yes.
And do you understand that if you chose to file a motion to withdraw your plea, that the court would have the sole discretion in deciding whether or not it grants that motion?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation, or you may be subject to revocation for the balance of your sentence?
Yes.
Do you understand that this is a plea which is permanently recorded on your criminal history? However, if you complete first offender, and we'll talk more about that in a minute, it would be removed from your record.
Yes.
You understand that if you were charged with a crime in the future, this plea could be used to enhance sentencing, including on a federal case.
Yes.
You understand that if you are currently on probation or parole, that your probation or parole may be revoked based on entering a plea today.
Yes.
And are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this plea, just as there would be from a conviction following trial? For example, your plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty under offered to a felony that you cannot receive, possess, transport, or own a firearm, that also includes while you're on first offender probation, or you could be charged with another felony?
Yes.
And are you asking the court to treat you as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere or ever been convicted of a felony in Georgia or any other jurisdiction?
No,
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
no,
And has your lawyer explained to you how the First Offender Act works?
yes,
Do you understand that if you violate the terms of your first offender sentence, or if you commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in the indictment?
yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea today?
yes,
And do you understand that by entering your plea, you are giving up the following rights, and I'm going to say each of them one at a time. The right to a trial by jury,
yes,
the right to remain silent and not incriminate yourself,
yes,
the right to see and hear the witnesses against you and to have your attorney question them,
yes,
the right to have the assistance of counsel hired by you or to court-appointed counsel at trial if you cannot afford an attorney,
yes,
the right to the presumption of innocence, which means that the state would have to prove that you are guilty of each charge beyond a reasonable doubt,
yes,
the right to testify on your own behalf or remain silent, and the jury would be told that they could not use your choice against you,
yes,
the right to present other evidence of your own and call your own witnesses if you choose to,
yes,
and the right to appeal if convicted of these charges after a trial.
yes,
And counselor, are you satisfied that your client understands these rights that she will be waiving by entering a plea to these charges today?
I understand.
Ms. Jones, has anyone forced, threatened, or promised you anything other than this plea agreement to get you to enter into a guilty plea today?
no,
And is it your decision to waive these rights that we just talked about and enter a guilty plea under Alford because you've decided that it's in your best interest to do so?
yes,
And are you aware that even if you do not admit guilt, that this will count as a guilty plea on your record and it places you in the same position as if you were convicted by a jury at trial?
yes,
And as to indictment number 25 SC 002906, how do you plead to count 1, violation of the Georgia RICO Act, counts 2 and 14, theft by taking, and counts 15 and 27, securities fraud?
guilty under Alfred,
And is your plea freely and voluntarily given with full knowledge of the charges against you?
yes,
And do you understand that you do not have a right to appeal directly from your plea, but if you believe that there was some error in your plea, that you could apply to the appropriate appellate court to request a discretionary appeal?
yes,
Do you understand that the discretionary appeal procedure, which is outlined at OCGA 5-6-35, must be completed within 30 days from today?
yes,
And do you understand that you only have 4 years from today, because these are all felony charges, to file a habeas corpus petition challenging the voluntariness of your plea?
yes,
Your Honor, as to a factual basis, if this case were to proceed to trial, the state submits that the evidence would have shown that on and between February 24th, 2019 and November 25th, 2022, the defendants, Kayla Brown and Trikella Jones, conspired and endeavored to acquire and maintain an interest in and control of United States currency through a pattern of racketeering activity in Fulton County, Georgia, and elsewhere. The primary objective of the racketeering scheme was to steal money from numerous unwitting victims through the operation of a sham securities brokerage. The defendants falsely represented that Brown was a licensed stockbroker and an agent of Global Investments LLC, which was an entity used to cloak the scheme in an appearance of legitimacy. The defendants received large sums of money from victims under the false pretense that the funds would be used to purchase stocks and other securities on the victim's behalf and for their benefit. To further the scheme, Brown created and assumed false identities and communicated with victims using fraudulent email accounts to create the impression that Global Investments was a legitimate business and had multiple employees. The defendants used social media platforms to post false and misleading depictions of wealth to lure victims in with the promise of financial success. The defendants would instruct victims to deliver funds to them via various methods. In some cases, Kayla Brown received those funds directly, and in other cases, she would instruct victims to make payments to Adrian Jones or the defendant, Trikella Jones, and then those funds would be routed to Brown. The specific funds that Trikella Jones received were $1,000 from victim Tanisha Brown on January 7th, 2020 via Cash App, $1,000 from victim Tanisha Brown on March 11th, 2020 via Cash App, $450 from victim Lynette Luke on March 5th, 2020 via Cash App, and $300 from victim Lynette Luke on March 20th, 2020 via Cash App. I believe that total is $2,750 received by the defendant. The combined loss was over $600,000, and all of these offenses occurred in Fulton County, Georgia. And I believe there are victims on the call, Judge, as I'm sure you know, that may wish to make a statement.
Okay. Question for you before we pivot to any new victim impact statements, different from what I may have heard before. Did your investigation uncover any receipt of benefits by Ms. Jones? You've described her role, it sounds like more as a conduit. So Ms. Brown and Ms. Luke both sent money to Ms. Jones, who then passed it on to Ms. Brown. You demonstrated at Ms. Brown's plea hearing what Ms. Brown did with the money. But I'm curious if there was ever any evidence you uncovered showing that Ms. Jones was a benefit directly, as opposed to, it's great, my daughter has some money, those are good things, but Ms. Jones, you could see money flowing into her accounts that came out of global, whatever you called it, that connects her beyond being a conduit where money flows into the scheme.
So a couple things there, Judge. I believe that the funds that we directly show going into Ms. Jones's Cash App account were directly then transferred to Ms. Brown. However, I believe that she did receive some collateral benefits. I believe that there may have been a vehicle purchase for her. I'll let the defense correct me if I'm mischaracterizing any of this, but I believe that there was collateral benefits, including potentially use of vehicles, potentially a residence.
That Ms. Brown was able to procure using the proceed, the 600,000 plus of her fraud scheme.
Yes.
Okay. The other co-defendant had a different disposition, but you described his role as being pretty similar to Ms. Jones's, that he may have received money from would-be investors and then channeled that to Ms. Brown. Is that a fair description of his role?
That's fair. The significant difference, Judge, is that if we had proceeded to trial, several of the victims would have testified that Ms. Jones was also present and received, I believe, potentially some cash. And also at least one would have testified that she wrote a receipt after some funds were given to Ms. Brown. So we believe that is a distinction from Mr. Jones that shows her intent and knowledge of what was going on.
Got it. And you're not including the cash received, as in dollar bills or $100 bills, whatever it would be, in the 2750, because those weren't routed through Ms. Jones's account. They would have been routed through her hands, in essence, that a victim said, here's the money I want to get to your daughter, Kayla Brown, head of global investments. Will you please give her this cash?
I want to make sure I'm not misleading the court. My understanding is that in those instances that Ms. Brown and Ms. Jones would both be present together when the funds were received.
Got it. Okay. So it was more of a greater awareness of the size and scale. I guess those are the same thing. The scale of Ms. Brown's operation, that Ms. Jones was present for more of it, whereas Mr. Jones, there just was a smaller amount that went through his hands or his accounts.
It was a larger dollar amount that went through his hands, but we didn't have any additional evidence beyond just the cash flow. Whereas with Ms. Jones, we do believe that there's significant additional evidence.
Okay. And Mr. Jones is Ms. Jones's brother and Ms. Brown's uncle.
Yes.
Okay. Got it. So let me turn to, one second. Let me turn to the Zoom application. I see many familiar names on the list of viewers and listeners. Is there anyone from our community of victims who would like to be heard in connection with Ms. Jones's?
Mr. Butler would.
All right, Mr. Butler, let me get you on the screen. I see the comment from Ms. Burbridge, nothing new, but I appreciate you being here, Ms. Burbridge, and I recall you from preceding sessions. Mr. Butler, good afternoon.
Good afternoon, Your Honor. Can I begin now?
Whenever you're ready.
Okay, thank you. On at least, based on what we just heard, on at least 2 occasions, when Ms. Brown and I met, she stayed on the phone and had her mother get items that she had me mail, or checks that she had me mail. And she said her mother was taking them to the bank on her behalf. So her mother received at least 2 of the checks that I sent, cashier's checks, and went to the bank and made a deposit for Kayla so that Kayla could verify it, while she and I were either talking on the phone or met at a local area. So she has, that's even more money because my checks were more than $2,000 that I submitted.
Okay, I want to make sure I follow what you're describing Ms. Jones's role to be. You and Ms. Brown were either on the phone or face to face, and the way you were contributing funds to her scheme was through a cashier's check.
Correct.
And Ms. Brown said, well, I want to confirm this is a legit cashier's check. So I'm going to have, did you know that Ms. Jones was her mother, or did she say, I'm going to have my associate?
No, I knew her as her mother.
Okay, I'm going to have my mom take your cashier's check to the bank to make sure they actually cash.
Correct.
And then you were either staying on the phone with or staying face to face with Ms. Brown until Ms. Jones calls her daughter to say, it's all good.
That's correct.
Okay, thank you for sharing that. That's yet another aspect of Ms. Jones's involvement in this. And I'm not remembering, I know it's in the documentation that Mr. Wooten already provided, but what was, when you're thinking about those 2 cashier's checks that you're talking about, ballpark, what was the size of your loss through that?
Through just those 2 cashier's checks?
Well, I guess overall, but those 2 checks first, they were about what?
I think one check was a little over 10,000 and the other one might have been about 1,500. My total loss is about 55,000.
All right, all big numbers. Okay, well, I appreciate you being here, and I appreciate you sharing that. Anything else you want to share with me?
No, Your Honor.
Okay.
Thank you.
Well, thank you. Let me see if there is anyone else. I got the note from, I'm not going to have your last name, so I have to say Shan, and I apologize. I'm not using your last name, but that's the way you entered the Zoom. Anyone else wish to be heard at this time? Okay.
Ms. Palmer, Deanna.
All right, Ms. Palmer, can you turn your camera on, please?
Sure. So Miss Raquella was there. My first initial payment to Kayla, which was $2,500. Miss Jones was the driver. We met at a local Walmart in my area, so she definitely was aware of, what was going on and the exchange of, this was cash. I gave her $2,500 cash.
Okay.
And Miss Brown was there, Miss Jones was there, and her daughter was in the back seat. So
when you say her daughter, meaning Ms. Brown's daughter, or Ms. Jones had another child?
Miss Brown's oldest daughter.
Okay.
Was in the back seat.
So whole 3 generations were there.
Mm-hmm.
Okay. And what I'm curious, I'm not pushing back in any way. I wasn't there. What makes you think that Ms. Jones would know why you were giving her daughter some money?
I can't see how she did. I can't see how she did not ask questions. She did not want to know why was it such a lump sum of money. Why were we meeting at a Walmart? Like, I'm sure she had questions.
Why is this lady giving you a bag of cash?
I questioned. Yes. Why?
Yeah.
$2,500. And on the strength of what? Like, I'm a mother as well. And I questioned my son, like, hey, what's going on? Why are you doing this? It has to make sense to avoid situations such as this. Situations where he's in trouble or I'm in trouble because of something he's done. But yep, she was definitely there. My first initial transaction, I'm sure she knew.
Okay, got it. Well, thank you for being here. I appreciate it.
No problem.
G, you've got your hand up. I assume that means you'd like to speak. but all I know is that it says G on your tile on the screen. All right, perhaps not. I'm going to then pivot to Mr. Campbell. I would like to hear from you. We've got Ms. Simpson on from probation. I don't think we have anyone from pretrial. Hey, Ms. Simpson, how are you doing?
Good afternoon, Judge. How are you?
I'm well. It's nice to hear your voice. Does your system have any information that would suggest that Ms. Jones was ever on felony probation in Georgia?
No, Judge, she is not. So I am under the impression she does not have any felony convictions in Georgia.
Okay, thank you. Mr. Campbell.
Thank you, Judge. Judge, as you heard from the state, Ms. Jones, she did not receive any benefits, all the financial money, anything that was sent to her was sent back to her daughter. We provided evidence of that to the state, checks that were written to Kayla. As the court is aware, Kayla, I think during her sentencing, she did testify that her father passed away, and then she came into, there was a settlement where she received some proceeds. So whatever money Kayla had coming in, or if she was helping Ms. Jones really wouldn't have had any way of knowing where that financial gain or benefit was coming from at the time. She really had no idea of the scheme, had no involvement besides maybe being present, as you heard, giving Kayla a ride or doing her a favor and depositing checks, as she's probably helped, deposit work checks in the past or watched her grandchildren. So she's decided that it's in her best interest to enter this plea under North Carolina v. Alford. As I said, she had no involvement or no knowledge of the scheme that Kayla had created, Judge. She just kind of a bystander, just being a mother helping her daughter, Judge. And we asked that the court accept the plea as negotiated.
Okay. Ms. Jones, Ms. Jones, I have a few questions. Do you have any questions before I get started?
No.
Anything you want to add to what Mr. Campbell said? Okay. Help me understand how it is that either you weren't curious and didn't ask questions of your daughter. This would be along the lines of what one of the victims just shared. Like, how would you not want to know why someone just handed your daughter a big envelope of cash? But it sounds like there were instances where your daughter wasn't around. You received something from a Tanisha Brown or Ms. Luke money, and then you transferred that to your daughter. Help me understand how it is that you either didn't ask your daughter, why is all this money flowing to you? Or if she said, oh, it's an investment thing, you didn't want to know more about what was going on. Does that make sense, what I'm asking?
It does.
Okay.
It does.
Well, help me understand that.
Okay, Kayla did personal investments for herself. And it was my understanding that Kayla was doing investments for others. So the monies that were coming to my cash out, that's what they were for. Investments that Kayla was doing for others.
Okay.
That's why I didn't question it.
Your daughter had been investing because of the money she had received through the settlement? Or
Correct.
that was just her line of work?
I don't want to give any false information.
Okay,
But from
take
my
your time.
understanding, she was told how to invest, so she started investing her money. I can't speak for any of the other victims, but for one, I know she knew of the settlement that Kayla received.
Who are we talking about?
Sean Thomas.
Okay,
She knew of, because that was my best friend.
okay.
So of course
Was.
I told her, yes.
Right,
So I told her.
okay.
I told her the amount.
Meaning you told Ms. Thomas, my daughter is investing,
No,
that there was a settlement.
Settlement.
Got it.
When she received it.
Okay,
So when Kayla started investing, Then Sean Thomas wanted to invest as well.
Got it. I want to do what you're doing.
Yes, make the money that Kayla's making is what she said to me.
Okay.
I want to make the money that Kayla's making.
And-
So with that being said, with the other victims, they were investing. So I can't speak of anybody else. I don't know of anything else. All I know is that incident. So when she would receive monies or when she would have money sent to me, I knew it was because of the investments.
When you say that Ms. Thomas said to you, I want to make money like she's making money, how was it in your understanding that Ms. Thomas would know that your daughter was a successful investor? Because it's one thing to get money because there's a settlement, but no one wants to make money that way. As a sad and difficult way to make money. So were you sharing with Ms. Thomas that your daughter was a successful investor, or were people on their own able to learn that your daughter was a successful investor?
No, she befriended my daughter.
Ms. Thomas?
Thomas did. They
Okay.
became closer than we were.
Got it. So they would have had their own interactions. Your
Correct.
daughter says what she says to Ms. Thomas, true, not true.
Correct.
That's not your communication with Ms. Thomas.
Correct.
Okay. That causes Ms. Thomas to develop a degree of confidence in, comfort with your daughter's supposed investments. She wants in, and it just so happens that you were the conduit for one of those payments.
Correct.
Or you were in the car when one of those payments was. Okay. And then similar with Ms. Brown and Ms. Luke.
And to speak of that incident with me being in the car, honestly, I don't remember.
Okay. Oh, I'm not saying that it happened, didn't
I'm
happen.
not-
It-
right. So
It
I
was
can't
distinctive
say-
in her mind.
Yes. So
Okay.
I can't say that but if I was present,
Yeah.
and money was exchanged, it was for the benefit of investing.
Got it. And so the response that would help me understand what I thought were good questions from the victim is that how would a mom not want to know what's this brown envelope with cash in it? Like, what kind of work are you really in? You were under the impression that this related to what you believe to be your daughter's legitimate, successful investment business,
Correct.
which for a few months might really have existed, at least for herself. We know it didn't exist for all these victims, that there wasn't an investment opportunity that yielded any kind of returns for them. I mean, you sat through the hearing, so you've heard what I've heard. Yeah, okay. And the money's gone. Their money isn't in Apple stock or General Motors. It is gone. So, okay. Where's your daughter now?
She's at her house.
Her house. Is her house the Fox Run address or the other address?
The other address.
I may have a typo with that. I have a question for you about that. Give me 1 second. Whoops. On Watson Circle,
Yes.
do you know what's the street number?
I have to give it now. Can I provide it later?
You can write it down, and because I may have the wrong one, and I want to make sure I get the right one. So Silver Fox is you.
Correct.
Got it. And that's not where she is.
No.
Okay. Where are her kids?
They are there at her house now.
Okay. Got it. All right. First offender. First offender you are eligible for, not having been convicted of any crime before, which is not surprising given your background. It is primarily an opportunity. If you are sentenced as a first offender and you successfully complete your sentence, then you heard what both your lawyer and Mr. Wooten said, that certain things can be expunged, sealed, et cetera, which makes it easier for you to continue to stay in your line of work of healthcare, if that's what you choose to do. But it carries with it a risk as well. The recommendation is that I sentence you to 5 years and that it all be probated. The actual maximums that are associated with the crimes to which you are entering pleas go a lot higher than just 5 years. And so I need to make sure that you understand that if first offender doesn't work out for you, you could be resentenced up to the maximum for the various offenses. And I've just been trying to find that would get us up to 60 years. I don't say that to make you think, gosh, if I don't do well on first offender because I get a speeding ticket, I'm going to go to prison for 60 years. That's not what's going to happen. But I will tell you that if 2 years from now we are together again and you are somehow directly or even tangentially connected to some kind of fraud situation, that's the kind of thing where I suspect the state would say you should revoke the first offender status and, independent of whatever the new allegations are, resentence Ms. Jones as a felon. And the state might be advocating for, and I might be open to, a meaningful chunk of custodial time, because it would be demonstrating that we were duped, that you were not way out on the periphery, and that you actually get mixed up in swindles like the situation that your daughter was operating. If you don't think that's a big risk and you're pretty sure that while you were on probation, staying out of trouble is going to be easy, then first offender is that's a simple decision to make. But I'm obligated to share with you the benefit and the risk so that you make a knowing decision about first offender. Do you feel like you understand the risks and the benefits of first offender status?
Yes.
Do you wish to be sentenced as a first offender?
Yes.
All right.
And Judge, I would like to clarify. So I did tell her that her case would be sealed under first offender on the front end. I just saw, I think the law changed on it recently, possibly. I just wanted to confirm that it will be sealed on the front end.
I won't get in the way of that. I'm not going to object to it. There may be some steps you need to take. The law did change, and I'm not super familiar yet with the mechanics of it. Whether it's an auto sealing, if the clerk sees first offender, then the clerk's not waiting for an order or a request. So you might want to adopt the belt and suspenders approach. First, if I were you, I would check with the clerk's office saying, could you take a look at the plea that was just entered? Is that going to be sealed? And if the answer is no, then run a draft by Mr. Wooten, but you can get me a sealing order. And I don't know that I've got a whole lot of discretion. I wouldn't oppose it anyway, but I don't think I have discretion. It's what the first offender statute says should happen if it's requested. I just think the new law, you don't even have to ask. It sort of automatically happens. I just, like I said, don't know what automatic means in this context. All right. Well, Ms. Jones, I find there's a factual basis for your plea. I also understand why it's an offered plea, but a jury could, I believe, from the evidence the state has and the testimony that the victims would give to that jury, they could conclude that you knew more about what your daughter was up to than you're saying you did. I don't need to solve that today because you're entering it as an offered plea, where you say you disagree with the state's characterization of the evidence, but it doesn't sound like you're disagreeing with some of the evidence that money changed hands and sometimes it went through your account or your hands. You just helped me understand what you thought was going on. And a jury might agree with that. And I understand why the state is working this case out this way instead of saying, by golly, Ms. Jones needs to go to prison or something like that. That wasn't your role in this. And through your lawyer, you have mounted what's a viable defense. But of course, it's expensive and it's risky to go to trial because a jury could decide that there was too much smoke surrounding what your daughter did for you to credibly deny knowledge of what she was doing to these many people who lost so much money in connection with what her scheme was. So there is a factual basis. I also find that your plea is knowing, meaning you've understood the things we've been talking about, and voluntary. No one's forced you to enter this plea. Do you agree with that?
Yes.
Okay. Mr. Wooten, do you authorize someone in my office to sign the indictment on your behalf?
Yes, Your Honor.
And Mr. Campbell, do you authorize someone in my office to sign on your behalf and your client's behalf?
Yes, Your Honor.
We'll do that. I will, Ms. Jones, follow the negotiated resolution in your case and sentence you to each of the 5 counts to 5 years. Those will all be concurrent. They will be probated. The special conditions of your probation, well, I will sentence you as a first offender. And the special conditions of your probation are those that Mr. Wooten spelled out when he was sharing with me what the joint recommendation was. I'll make sure those are included in the final disposition. And that'll be how we handle this. Mr. Wooten, anything else on behalf of the state?
No, Your Honor.
Anything else, Mr. Campbell?
Nothing further, Your Honor.
Okay. Ms. Jones, any questions?
No.
We have Ms. Simpson. You heard her voice a little earlier from probation. She will not be your probation officer, but she is with probation. I'm going to put her on the screen here. She's going to give you some reporting instructions, and she may have a question for you about your residence, not your street address, but what county in which you live. So she can give you reporting instructions. Okay? Ms. Simpson?
Thank you, Judge. Ms. Jones, I believe I heard you earlier correctly. The address that is registered in the system, that is still your correct updated address?
Correct.
Okay, so that is, I believe you're under Paulding County?
Yes.
Okay, so that office is virtual. I'm going to give you the number.
What does it mean to have a virtual office? No one has to report in person?
For Paulding County, they do not have a physical office, Judge.
Well, you lucked out. Okay.
So I'm going to provide you the number to contact them, and an officer will meet with you to schedule a mutual meeting location so that you can report. Let me know when you are ready.
Hold on. Mr. Campbell is going to get it in his phone, and then he'll forward it to Ms. Jones.
Okay, I'm ready.
It's area code 678-224-4397.
Got it.
Make sure you contact that office, preferably first thing tomorrow morning.
Will do.
Is there an email address too, possibly?
There is not for now. The officer that she will speak with will let her know who her assigned officer will be.
Thank you.
Thank you. If you want, you can list my number as a secondary contact.
Perfect.
All right. I think that is everything.
What's your number?
It's 404-783-9218.
Thank you.
No problem.
All right.
Thank you,
Thank you,
Judge.
Ms. Allen, for your time.
You're very welcome, Your Honor. You'll have a good